Hello, and thank you for joining us for today's webinar presented by McLane Law Firm. My name is Mike McLane, the Marketing and Business Development Manager here at McLane, and I'll be your moderator today. Our presenters for today's webinar are McLane Directors Bill Zorn, Steve Burke, and Ryan Swartz. Bill Zorn is the Vice Chair of McLane's Trust and Estate Department. He concentrates his practice in sophisticated estate planning, including the implementation and administration of tax strategies and trusts for high-income and high-net-worth individuals, executives, and banking owners, as well as strategies involving asset protection and wealth preservation. Steve Burke's practice is devoted to advising on business, governance, and tax planning, transactions, business succession, and sophisticated executive compensation. Also a CPA, he advises high-net-worth individuals, families, and fiduciaries on estate planning, trust administration, and wealth preservation. Ryan Swartz advises individuals and families regarding various estate planning matters, including estate, gift, income, and generation-skipping transfer tax strategies. He advises fiduciaries in conservatorship, probate, and trust administration matters, while also counseling individuals and business owners on succession planning and various asset protection techniques. Today, our presenters are here to continue on their November presentation regarding the differences between Massachusetts and New Hampshire trust laws by discussing the benefits and mechanics of migrating a trust to another state. We will have a question and answer session at the conclusion of the presentation, so if you do have a question, you can use the question feature on your control panel. That will send your questions to me, and I'll ask them at the conclusion of the presentation. So without further ado, I will turn it over to our presenters.
Thanks, Mike. This is Steve Burke. Good afternoon, everybody. As Mike indicated, our topic today is the importance of mobility or portability of trusts. In other words, moving a trust from one state to another. I think it's important just for a second to remind everyone what a trust really is. In essence, if you look at it this way, a trust is really a receptacle or a silo to hold property. It's run by a trustee who's the legal owner of the trust assets and acts as a fiduciary for the benefit of course, the beneficiaries, following the rules set by the settlor or the grantor of a trust. And we're going to talk a lot about each of those parties along the way today. Remember that an irrevocable trust is a separate taxpayer and pays both federal and state tax on its accumulated income. And we'll talk about that and the differences on a state-by-state basis as well. It's also important to remember that a trust is a creature of state law, both state statute and state common law. And Bill and Ryan will talk a lot about the differences among state statutes and state common law. But also trusts are a creature of the trust document or the law of the trust document itself. And we're going to talk about the differences among different trust documents along the way as well. We're going to focus today on irrevocable trusts. Over the years, irrevocable trust, or the words irrevocable trust, have almost had a frightening connotation. So we're always concerned with what is in place at the creation of the irrevocable trust could stay in place forever, which would mean a trust would be almost fixed or stuck in time. So you'd be stuck with the existing trustees, stuck with the existing state taxation, and stuck with existing reporting requirements. And as I'm sure most of you know, these differ dramatically state to state and, of course, document to document. So it would be great if it were possible to move a trust from one state to another. Some states are trust-friendly, and some states, of course, not so much. So again, our focus today is on the ability of moving a trust from one state to another. Of course, the basic foundations of trust law, which I won't bore you with today, predate the founding of our country. They go back a long, long way, hundreds and hundreds of years. But over the last decade, there really has been a tremendous modernization of trust law in some, but not all, of our states. In addition, the concept of irrevocability of trust, easy for me to say, has really changed. Trusts are no longer considered to be immovable silos. So the concept of mobility, trust mobility or portability, has emerged from these changes. Now there's an ability to, as we call it, migrate trusts from one state to another to take advantage of more favorable conditions in one state or another. So there's many good reasons to do this, including, and we'll focus on many of these today, improve basic estate planning, basic estate administration, wealth preservation, and of course, my favorite, state taxation savings. But this is really tricky business. It's not easy to do. There's many traps for the unwary. We're going to focus today on the what, how, and where to of trust migration. So we're going to split this up in different ways and alternate speakers along the way. So our approach today is going to be as follows. First, I'm going to provide a quick overview of the whys of mobility and the benefits of migrating trusts through the first few slides. Then Bill is going to start the hard work, talking about the mechanics of migrating trusts, the use of non-judicial settlement agreements, trust modifications, decantings, etc., and the reasons to use each of these fairly sophisticated tools. Then Ryan's going to talk about or expand on the benefits of mobility, migrating trusts, and the differences among state laws. Bill is going to come back and talk about the challenges of mobility, the hurdles you face when migrating a trust from one state to another. After that, I'm going to come back and talk about trust status and state taxes and some state tax planning, getting out clean and getting in safely from one state to another. Then Ryan will come back and focus on the importance of trust language and the ability to change a trust from one state to another. Then Bill will come back and focus on governing law and really the differences between governing law and situs. And then finally, I'll come back with a few words relating to, a few words of caution, I should say, relating to the generation skipping tax, the gift tax, and income tax issues. So just moving quickly to the second slide. Here we've got a laundry list of the benefits of migration. And I won't go through all of them, but you can see they vary or range from everything from state tax savings to limitation on liability of trustees to using more useful trust provisions available in one state law versus another. The themes really are, better tax planning, more efficient administration, both from a cost and reporting perspective from one trust state versus another, to trustee protection, to wealth preservation, and a better ability to carry out the grantor's intent. Moving to the next slide, really focusing on the mechanics of migrating a trust from one state to another. Again, it's important to prepare for the move, to study not only the trust itself, but the state law of the state of the current status of the trust, and also the state law of the destination of the trust. It's critical to understand the differences between both trust situs and governing law. We're going to talk about that a little bit later as we continue down the road. So to the next slide, focusing just for a minute on tax planning. Tax planning, of course, is very important in this area. And frankly, in some cases, it's the predominant reason for moving a trust from one state to another. As Bill and Ryan will talk about, there are many other great reasons to do so, but saving money and a bad one as well. And as we'll talk about a little bit further, states do differ dramatically on the taxation of trusts. So the implication over time on a trust and on the accumulation of trust income can be very, very significant. But again, moving to a tax-friendly state is just not that easy. There's really two steps in the process, and it's always important to remember these two. First is to get out of the state that you're in now, clean, getting out clean. We'll talk a little bit about that with a Massachusetts example in a second. And then second, the second part of it, or the second step, is to arrive safely in the tax-friendly or statute-friendly state. So getting out clean, and then, as I said, arriving safely. There's no more, moving to the next slide, stark example of two states that differ from a state tax perspective when taxing trusts than New Hampshire and Massachusetts. And I'll talk about in a second. The difference is simply that Massachusetts taxes trust accumulations of income at the rate of a little bit over 5%, and New Hampshire doesn't tax them at all. So very, very big difference. So on slide 5, what we're talking about here is getting out of Massachusetts. And here we're talking about what is a resident trust for Massachusetts tax purposes. So are you in Massachusetts for purposes of having to file a Massachusetts return and subjecting the trust income to taxation? And as the slide said, there's really a two-part test. The first is, at least one trustee of the trust must be a Massachusetts resident. And the second part is a multi-part test. One of the following must exist. At the time of the creation of the trust, the settlor or grantor was a Mass resident, or the settlor was a resident of Massachusetts at any time during the current tax year, or the settlor of the trust died as a resident of Massachusetts. But if you think about this two-part test, the implication is if you lack one of the two, and I'm going to focus on lacking a trustee in Massachusetts, then you are no longer a Massachusetts trust. You become a non-resident trust with respect to income from sources within Massachusetts. So it is a big deal. Saving Massachusetts trust taxation or taxation on the trust income can be very, very significant. Of course, when the trust income is distributed to a Massachusetts resident, under federal law, it carries out income at that time and, of course, would be subject to Massachusetts taxation at that time. And finally, next on slide 6, focusing on New Hampshire. Again, we would view New Hampshire as a trust-friendly state, certainly from a tax perspective. As most people remember, New Hampshire is a no-income tax state. There is no personal income tax. There is, however, a tax on interest and dividend income at the rate of 5%. However, non-grantor irrevocable trusts are specifically exempted from that tax. So that means that if you've got a trust that has safely gotten out of Massachusetts and established itself in New Hampshire, you no longer are subject to taxation in Massachusetts, and in New Hampshire, of course, the income will grow state tax-free. At this point, Bill is going to take over.
Good afternoon. This is Bill.zorn, and I'd like to start with an apology. Came back on an airplane a few days ago, and I think picked up a terrible cold, so I apologize if the vocal is not quite what it should be. Focusing on the second significant reason why trusts are migrating to a different jurisdiction is to the extent they want to modify the terms of the trust. We see this frequently where trusts were drafted 20, 30, 40 years ago, and the beneficiaries and trustees are looking at what mom and dad or grandma and grandfather did decades ago and said, gosh, if we could look at what the current situation is, certainly we would want to amend the trust terms to reflect the current circumstance. And you'll see that there are 3 techniques that are probably used the most with regard to reforming trusts, and those are trust modifications, non-judicial settlement agreements, and decantings, and I'll explain to you why we have them in that order. You'll see at the bottom of slide 7 some of the common reasons for reformation. Certainly modifying beneficial interest, including the removal of withdrawal rights or insertion of special needs provisions. Certainly there are children that are born, grandchildren that are born who are beneficiaries of trusts, and for government assistance programs for potential misuse of trust distributions, it would be ill-advised for the existing trust terms to allow distributions to go out to those beneficiaries. In certain circumstances, allowing the beneficiary to direct trust assets at a later date, referred to as a power of appointment over trust assets, is something that would enable the beneficiaries to have additional flexibility moving forward. And so long as those powers of appointment are consistent with the settlor's original intent, we can modify the trust in that regard. Certainly, the wave of the present is potentially to divide up responsibilities, and Ryan will talk about that, between investment advisors and trust distribution advisors and administrative trustees. Certainly, that's another reason why a trust would be reformed. The other one that we see frequently where there's a reference to adding trustee powers and administrative provisions, one looks back and looks at who the successor trustees are of the trust And while they seemed appropriate 20, 30, 40 years ago, whether it's age, geographic changes of those people, etc., it may no longer be appropriate, and therefore changes in successor trustee provisions are frequently seen. There are certainly situations where we want to change a trust from being a standalone non-grantor trust to an intentionally defective grantor trust and dividing up assets. In terms of the techniques, I put at the top option 1, which is trustee modifications. Why is that the first consideration? The reason for that is if you're modifying a trust, you'll see that an independent trustee can modify the trust without court approval, without consent of the settlor, and without consent of any of the beneficiaries, so long as the modification furthers the settlor's intent or material purpose of the trust. Assets don't need to be changed from the old trust to the new trust. The old trust is simply modified. The trustee does have an option to notify the beneficiaries if there's any concern and alert the beneficiaries that they have 60 days to object to the modification. Certainly there's conversation that goes on before a modification and understanding that the beneficiaries are most likely on board, but there is a provision for the trustee to be protected. There's a reference to the New Hampshire law. Trust modifications are relatively new. In New Hampshire, they came into effect on July 1, 2014. So a new technique, but they are being enacted in a number of states. Massachusetts is not yet one of those. Option number 2, non-judicial settlement agreements, again is a reformation or modification of an existing trust. So again, there's not a new trust created. Assets do not have to be transferred from one trust to the other. So both in New Hampshire and in Massachusetts, there is a statutory provision that allows for all of the beneficiaries, non-judicial, meaning obviously outside of the judicial, outside the court system, to get together and unanimously agree to modify the trust. There is a distinction, as you'll see on the bottom of page 8, that in New Hampshire, beneficiaries can actually agree to terminate a trust or modify it in significant, substantial ways, where in Massachusetts, the non-judicial settlement agreement is more dealing with exclusively administration provisions. Interestingly, in both states, by non-judicial settlement agreement, there can be a change of the principal place of administration, which gets to migration. The third option is to decant, and that's a strategy where the trustee actually distributes assets from the first trust into a second trust. And again, that's the most dramatic in that there's truly a shifting of assets from one trust to the other. Steve Burke will chat with us later on about there are income tax considerations, sometimes gift tax and estate tax considerations, as well as generation skipping tax provisions. In terms of state laws in Massachusetts and New Hampshire, I'd like to actually start with Massachusetts and take them in reverse order. There's a wonderful case, Morse versus Kraft. That's Jonathan Kraft of the Patriots, which makes it even more interesting to read. It's a 5-page decision, so it's not heavy lifting. Essentially, there was a case in Florida in 1940 called Phipps versus Palm Beach Trust, which really is the seminal case. And the thought there is, and I'm reading from what the court wrote, because the terms of the trust vested the trustee with unlimited discretion as to the time, amount, manner, and condition of any sums to be paid, the general rule of trust says that the power vested in the trustee includes the power to create or appoint, in fee or otherwise, those assets onto an additional trust unless the donor clearly indicates a contrary intent. So the court in Massachusetts looks at the trust that the Kraft set up and came to the conclusion that indeed there was full discretion within the trustee, and then went on to say, moreover, the settlor, Robert Kraft, and the plaintiff's disinterested trustee all submitted affidavits to the effect that they intended the 1982 trust to allow distributions to new trusts without the consent or approval of any beneficiary or court. They go on to say the decanting authority turns, and here's the scary part, on the facts of the particular case and the terms of the instrument creating the trust. There is no fixed rule by which all are determined. So we have a case, and as the slide says, there are a few guidelines here. A brief survey of mass practitioners indicate that indeed decantings are going on. It's critical that you look at the verbiage of the trust to determine whether or not the trustee has that discretion. Some practitioners are actually signing affidavits similar to what the settlor Robert Kraft and the disinterested trustee who drafted the trust. So there is the possibility to decant in Massachusetts, but in limited circumstances that align themselves with the Kraft case. In In New Hampshire, there can be a decanting, and the state statute, which originally was enacted in 2008 and reenacted in full on July 1, 2014, makes it clear that a trust can be decanted even if the first trust does not have full discretionary powers to the trustee. For example, if the trust says income is to be distributed for comfort, support, health, education under the New Hampshire statute, the trustee can still decant into a second trust, and that second trust may or may not have a discretionary distribution standard, may or may not have powers of appointment. So the New Hampshire statute is far more progressive or liberal, and when we're thinking about migrating, we may want to migrate from Massachusetts to New Hampshire or to Delaware to allow for those more liberal decanting opportunities. And with that, I'm going to turn the podium over to Ryan Swartz, who will talk us through some additional benefits.
Thank you, Bill. So we're talking about the various benefits of migrating a trust from one state to another, and as Steve and Bill have touched on, tax avoidance and flexibility through decanting, non-judicial settlement agreements, really two of the major benefits of moving to another state. But there are certainly others that are worth mentioning. Directed trusts. Some states do not have statutes that allow directed trusts. Massachusetts is one of them. We have a very brief reference in our Mass UTC regarding the trustee directing certain actions, but it's certainly not as comprehensive as what you would find in other states that have broader, more progressive uniform trust codes, such as Delaware, such as New Hampshire. So a trustee may be interested in moving a trust to another state to take advantage of that state's directed trust statute. And under those statutes, the trust responsibilities can be divided among several advisors / fiduciaries, and that may very well be attractive to a trustee who is on his or her own, or an institution that is on its own with respect to trust administration matters. Under a directed trust statute, responsibilities can be divided, and responsibilities regarding trust investments can be the responsibility of an investment advisor or an investment committee. Distributions can be the responsibility of a distribution advisor or a distribution committee. There can be an administrative trustee who is not responsible for distributions, investments. The administrative trustee would be handling bookkeeping, tax returns, reports, but would not be doing the heavy lifting that a traditional trustee would be doing. This may be very attractive for a trust that holds non-traditional assets. For example, many of the irrevocable trusts that we deal with were funded with closely held stock or very broad real estate holdings or private equity investments, things that you don't find on an open market that would be a traditional trust investment. And the trustee may be very hesitant to hold those assets for fear of not complying with a prudent investor rule or for concern about those assets significantly depreciating in value given the lack of control that the trustee has over those types of investments. And in that case, the trustee may be persuaded to seek a migration to another state with a directed trust statute so that the investment responsibility can be the responsibility of an investment trustee. And in New Hampshire, for example, in that directed trust scenario, the trustee would be relieved from liability for the trustee investments. Or if you had a distribution advisor, the trustee would be relieved from liability as to those distributions. In that case, the trustee would be considered an excluded fiduciary and is essentially off the hook for those responsibilities. Another benefit of migrating to another trust would be to take advantage of the abolition of the rule against perpetuities in the transferee state. For example, in Massachusetts, we have our traditional rule against perpetuities, and we also have what's called a wait-and-see 90-year rule against perpetuities. But Massachusetts has not yet abolished its rule against perpetuities, and we don't know if and when that's going to happen. Other states, such as New Hampshire, such as Delaware, have abolished the rule against perpetuities. And just to kind of bore you with the arcane issue of the rule against perpetuities, it's a long-standing rule that essentially encourages, or I'm sorry, discourages assets from being tied up in trusts forever. But as the decades have gone by, the rule has slowly eroded to the point where in some states it doesn't exist, and you can have a trust exist into perpetuity. So where you've had a trust that's lasted for a long time, and the rule against perpetuities is going to cause the trust to terminate at some point in the not-too-distant future, the trustee and the beneficiaries might be encouraged to move to another state where there is no rule against perpetuities. Certainly there are tax issues involved with that, and Steve will mention that a little later in the presentation. A few other quick benefits of migrating to another state. Some states have better asset protection statutes than others, especially when it comes to spendthrift provisions within the trust. So, for example, if a beneficiary is in a high liability profession, or if there's the prospect of divorce, the trustee would be well advised to consider other states that have stronger asset protection statutes than what is currently the case in the trustee's home or in the trust home jurisdiction. Enforcement of no contest clauses. It may be the case that the state does not have, where the trust is located, the state does not have kind of a well-thought-out, well-developed body of law, whether by statute or common law, of no contest clauses. Some states do not allow no contest clauses. For example, Florida provides that they are void because they violate public policy. But other states have very well-developed statutes, and in New Hampshire, for example, there's a very prominent case called the Tamposi case, which really sets forth some pretty specific guidelines as to when a trust can and cannot be contested. A few other quick benefits of migration, and then we're going to move on to the actual mechanics of moving to another state. Limitation period on claims against the trustee. Some states have a fairly short period of time within which a beneficiary can challenge a trustee's report. Other states have longer periods of time where objections can be filed. A benefit that we often encounter with clients is their desire of the original settlor to have what's called a quiet trust. What that means is, in most states, there's a mandatory obligation typically through the trust document, but if not through state law, for the trustee to provide an accounting/report of the trust. And we've encountered many clients who don't like the idea of their very young beneficiaries of the trust to be exposed to certainly the value of the trust assets, the composition of the trust assets, and it might be encouraging for the settlor and the trustee to know that in some states there is no duty to report to the beneficiary the existence of a trust or the necessity of filing an annual report for the beneficiary to review. So again, if there are young beneficiaries or there are immature beneficiaries who really wouldn't benefit from seeing that information and it might circumvent some of the settlor's purposes, it may be appropriate to move to a state that allows quiet trusts. And finally, New Hampshire has a very flexible, and other states do as well, Delaware, for example, they have very flexible statutes when it comes to the trustee's ability to adjust between income and principal or convert the trust into a unitrust. And what I'm referring to there is when we have an irrevocable trust that has income beneficiaries, it may be the case that the trust investments are not generating the kind of return that the income beneficiary would like to see. So, for example, if the income beneficiary is receiving a 1 to 2% net return distribution from the trust, and there's no way out of that scenario in the home state, it may be appropriate to move the state, migrate the trust to another state that allows for the conversion of the trust to a unitrust, which is essentially giving the trustee the ability to tap into both income and principal of the trust to create a unitrust payment of anywhere from 3 to 5% distribution to the income beneficiary. So that's another reason why a trustee may consider migrating. So we've talked about the various benefits of migration. Certainly, if the trustees and the beneficiaries, or perhaps even the settlor, have raised the issue, what they would want to do is certainly be very fully aware of the statutes in the home state, consider the different jurisdictions that have more flexible statutes, common law regarding trusts, and contact counsel in both of those states and get a very full and developed understanding of what the pros and cons are of migrating. And with that, we're going to move into the actual technical aspect of migrating to another state.
Thank you, Ryan. This is bill.zorn again. So starting with the mechanics of migration, there are certain, and Steve talked about traps for the unwary, and there's certainly obstacles that need to be considered. So let's start with the first one, which is, what is the operative language in the current trust, and is there the necessary migration language? And as Steve indicated, really the evolution and distinctions of state trust law has come about in the last 10 to 15 years. And not surprisingly, there are probably a majority of trusts that don't have migration language in them. Really, there are trusts that have a provision that talks about governing law. There are some trusts that have a provision relating to situs. There are certain trusts that have governing law and situs. And lastly, there are some that have governing law, situs, and then the migration provision. So just to set the table, frequently you'll have a trust, and just paraphrasing a little bit, the settlor declares that this agreement and trust are construed and administered under the laws of the Commonwealth of Massachusetts, and that the validity and effect of this agreement shall be determined in accordance with the laws of the Commonwealth. Period. That's all that's said. Totally silent on situs, totally silent on migration. So this is the language that we are now seeing in many trusts, which says, notwithstanding, the trustee may at any time, in his discretion, may remove all or part of the trust estate and hold and administer the same in any other jurisdiction where the trustee shall then be located. 2, change the situs of the administration of any trust from one jurisdiction to the other. And 3, elect that the law of such other jurisdiction shall thereafter govern the trust. And there's obviously language, that's exculpatory, and the trustee can do it in their discretion, but doesn't have to, so on and so forth. So the very first issue is, what are we dealing with in terms of a trust instrument? And as I said, frequently we're running into trusts that are simply silent on that issue, and that then, depending on what the language says, we're going to go in a couple different directions, which we'll outline shortly. Occasionally, you'll actually have dissension between the beneficiaries and the trustees, or amongst the beneficiaries and other beneficiaries, or even amongst the trustees. So certainly there needs to be a universal approach. Occasionally, some of these decantings, or I misspoke, migrations, may impact on certain beneficiaries in a way other than other beneficiaries, and trustees certainly need to be mindful of the fiduciary duty of impartiality, that you can't favor one set of beneficiaries over the other, of course, unless there's a stated level of priorities amongst the beneficiaries. The third area that one needs to think about is choices of law. And the issues frequently arise there is if you're changing situs or jurisdiction and you have assets, i.e. real estate, in multiple jurisdictions, you may have difficulty moving those assets from one jurisdiction to another. And you can also have multiple trustees in multiple jurisdictions, and that may also create issues relating to changing law, which frequently results in potentially reordering of trustees and resignations and reappointment of trustees. And certainly, where there is not appropriate enabling statutes or trust language, it may be required that a trust has to go to court to be reformed. And then obviously there's the costs associated with that. Now, as we've been talking about, there is a difference between situs, i.e. where is the trust located, and the governing law. With regard to situs, Steve has highlighted that there are key distinctions when it comes to state trust taxation. We have also had clients be very concerned about situs with regard to if litigation is brought, if the trust is situs in a particular jurisdiction, most likely that is the form in which the litigation is going to be brought. I think, as we all know, Delaware has the Court of Chancery, and New Hampshire has its own trust specialty court, and in certain circumstances, clients prefer to have those jurisdictions involved. In other cases, they do not. So situs is really a two-edged sword. In terms of governing law, that's the law that's going to govern the validity, the construction, and the administration of the trust. And in a trust instrument, it's possible to name a law which, quite frankly, has no other relevance to the trust or connection with the trust. One of the issues where we see perhaps most frequently is individuals that originally were residents of Massachusetts or New Hampshire that now are domiciled in Florida. Lawyers frequently will have those Florida domiciliaries still have the trust governed by Massachusetts or New Hampshire law, even though the settlor and perhaps the beneficiaries are in other jurisdictions. So as the slide indicates, moving the trust situs, and just for ease of discussion, from Massachusetts to New Hampshire does not automatically mean that the governing law is then also going to switch from Massachusetts to New Hampshire. Again, we have to look at the trust instrument to determine if the trustees can change that or if there's another procedure that needs to be undertaken. And why do we care about governing law? As I mentioned, there's the validity of it, and as Ryan talked about, if there is no rule against perpetuities in New Hampshire, clearly or Delaware, a trust could go on for a significant period of time beyond what would be allowed in Massachusetts. So you've got questions about trust validity. How does one construe, interpret the trust. That can impact on the identity of beneficiaries. And then how is the trust administered, the powers of the trust, as Ryan was referring to, directed trust, trust advisors, trust protectors, trustee notifications. Do you have a quiet trust, not a quiet trust, a liability of the trustees? So governing law can have a profound effect. And so we want to keep focused on both situs as well as governing law.
Thanks, Bill. This is Steve Burke again, and we're going to move to slide 18, and we're going to focus situs for purposes of taxation. So this is the get out clean part of the equation. Again, two parts of state taxation, situs for state taxation, getting out clean and arriving safely. So as you can see from the slide, there's really three general ways states, in general, again, focus on situs for state taxation purposes. They either look at the location of the settlor or a resident of the settlor, the location of the trustee, or both, or either, I should say. And it really differs from state to state, and the implications are very, very significant. So on our slide here, we're focused on three different sets of states: Connecticut, Vermont, and Maine on the one hand, Massachusetts and New York on the other, and California and Arizona on the third part. So just to focus on Connecticut, for example, again, what we're talking about here is getting out clean, moving a trust from Connecticut to, say, New Hampshire, and trying to get out of Connecticut taxation and into New Hampshire taxation, which, of course, in our example means no taxation from an irrevocable trust perspective. It's very, very difficult to leave Connecticut. Connecticut has a law that says if the grantor was originally a resident of Connecticut at the time of the creation of the trust, then that trust will forever be subject to Connecticut taxation, which seems almost incredible to me. And when I first heard that, frankly, didn't believe it until I read a Connecticut Supreme Court case which upheld that provision. So at least from a Connecticut perspective, it is very difficult to get out of Connecticut from a state tax perspective in the event that the grantor settlor created the trust as a Connecticut resident. There are other things that can be done, very aggressive strategies, including uses of powers of appointments and decanting, but again, not for the faint of heart. To mix metaphors, lots of traps for the unwary. Other states, like Massachusetts, as we talked about before, have a two-part test, and it's actually fairly clear. And as I'll talk about in a second, really the two-part test in Massachusetts really involves avoiding one of the two parts, which is usually avoiding having a Massachusetts trustee. And once you've done that successfully, then you no longer have Massachusetts situs for state tax purposes, and you're out. Again, you're out clean. Other states, such as California and Arizona, really focus on the domicile, exclusively on the domicile of the trustee. So you think that would be easier. Unfortunately, or maybe fortunately if you're with the taxing authorities in California, California has what's called a throwback rule. Really, it's a tax on accumulation. So in the event you get out of California, you get the situs out of California, to the extent that there is a subsequent distribution to a California beneficiary, the income that accumulated during that interim period is subject to taxation at the moment of distribution in California. So it's really a very complicated equation. Doesn't mean you can't do it, but again, very, very tricky when dealing with California. Moving on to slide 19, just a quick review of the Massachusetts and New Hampshire example. Again, we talked extensively already about getting out of Massachusetts. Remember that two-part document, and here in this situation for resignation and removal provisions. Can you actually, who can remove and replace a trustee? Do you need to actually go to probate court to petition for the removal of a trustee if there isn't any removal power within the trust itself and the trustee refuses to resign? So really important to get that process right. Moving to slide 20, the mechanics of migration continued. This, for a moment, is the arrive safely part. You've got to really carefully review the trustee appointment along with the removal, but the trustee appointment provisions to make sure that you've got the requisite power to get a trustee appointed in the new state. Again, if in our example of moving to New Hampshire, you've got to have the right to appoint someone who has the requisite New Hampshire location for purposes of establishing situs in New Hampshire. And of course, I think as both Bill and Ryan have talked about, the Uniform Trust Code does provide for many or fill many gaps, including the appointment of trustees where the actual document is silent. And just a quick point back to the getting out clean part. Remember to file a final state tax return in the state from which you're leaving. In my example, in Massachusetts, it's important to put the state on notice that the trust has left the jurisdiction, frankly, to begin the running of the statute of limitations. We'll talk about some other tax issues in just a bit.
And Steve, would you say when you move trustees that it would also be helpful for the original trustee to file an accounting and then have the new trustee and the new trust sign some type of receipt and reimbursement agreement or something like that to just augment?
Sure. Certainly for purposes of the trust, from the trustee's perspective, it would be very important. Getting out clean means not only getting out of the state from a tax perspective, but if you're the departing trustee, certainly you want to draw a line in the sand with respect to your performance of services and rendering and accounting to the beneficiaries, and certainly a refunding agreement if you're going to move assets and you're on the hook from a fiduciary perspective. Again, you want those beneficiaries signing off on that liability. So we're going to move now to quickly, since we're running out of time, to slide 21, and Ryan's going to pick up with the mechanics of migration.
So remember, we have really a two-step process here of migrating. We have to change situs, which Steve just talked about, and then we have to change the governing law. And changing situs is oftentimes much easier than changing the governing law. So how do we do that? Well, the easiest solution is if we have the appropriate and necessary language in the trust document. So as Bill mentioned earlier, the ideal language that we like to see, and in many cases we include in our own trusts, is a change of governing law / situs provision that gives the trustee the authority to remove the trust estate, administer it in another jurisdiction, change the situs, and elect the law of another state to govern the trust. It may be the case that there's no language to that effect in the trust document, but don't give up there. There may be other provisions in the trust document that allow the trustee to change the governing law or to another jurisdiction, or perhaps the beneficiary or one or more beneficiaries has a power in the trust that allows us to get into another jurisdiction. So for example, the beneficiary may have a power of appointment that can be exercised to get the assets into another jurisdiction. Unfortunately, most older trusts, and even many recent trusts, do not include this specific language in the trust document. And in that case, it gets more complicated. Choice of law principles will apply, and we're really looking at some older and newer principles within this area of law. The Restatement of Trusts has various sections regarding how to determine which state laws apply, and the UTC has buttoned a lot of those issues up as well. In many cases, when the trust owns real property, the laws of the state where the real estate is located will govern the trust. In the case of personal property, we have to essentially analyze which state has the most significant relationship with the trust. And there have been many cases in a multitude of states regarding this issue, in some states focus on certain aspects more than others. For example, where is the trustee located, where are the assets located, the domicile of the settlor, the location of the beneficiaries. The UTC tries to give some meat to this issue by saying that the meaning and effective terms of a trust will be determined by the laws of the jurisdiction that have the most significant relationship to the matter at issue. Now, if the trust is silent on changing status in governing law, there are options. So one option is to file a court petition asking that the governing law of the home state be moved to the transferee state. Or if we don't go to court, we can rely on state law, i.e. the Uniform Trust Code or common law. Now, unfortunately, if you're going to go through this kind of analysis where you're relying solely on state law and the change of situs and change of governing law provisions of the Uniform Trust Code, you're not going to have the same level of assurance or finality that you would have with a court order, and you won't have the same level of confidence that you would have relying on other techniques to change the governing law of the trust. So I think it would be rare where we would change the governing law solely based on an analysis of choice of law principles, because there may be some gray area, there may be some interpretation that a beneficiary may make that the trust really didn't move to that other jurisdiction. So in that case, we really want to rely on other principles of law in order to affect the change of the governing law. And with that, I'm going to move the presentation over to Bill, who's going to get into some specific techniques on how to do that.
Looking at slide 24, sometimes if there is not a change of situs and change of governing provision, please continue to look at your trust instrument, because there are frequently times in the trustee powers section that provides that the trustee has the authority to either merge or consolidate trusts which are similarly situated, or the beneficial interests are substantially similar. So there may be a provision where a separate trust can be set up and then the original trust merged into that. There is also a provision in the Uniform Trust Code that allows for trust consolidations. That provision is both in Massachusetts and in New Hampshire. If you go the merger and consolidation route, apropos of Steve's comments of a few minutes ago, frequently notice is provided to beneficiaries, a final accounting, a receipt and refunding agreement, and in some cases we've gone so far where there's a level of angst or uncertainty from a legal liability point of view on behalf of the trustee to actually have the beneficiaries indemnify the trustees for undertaking the action. Alternatively, if there isn't that merger language, as we've talked about several times, there's the possibility of a non-judicial settlement agreement. Again, there is in the Uniform Trust Code, both in Massachusetts and New Hampshire, the provisions for a non-judicial settlement agreement. Interestingly, the statute in both states talks and indicates that the beneficiaries can change the place of administration, i.e., I read that to be situs, but is silent with regard to the governing law. So there's been some discussion as the list of powers that can be achieved under a non-judicial settlement agreement is a list which is not exhaustive. Could indeed all the beneficiaries consent to a change of the governing law? Reasonable people can differ on that. So one strategy is it's possible to have a non-judicial settlement agreement ultimately after signed submitted to the court. So I guess the non-judicial settlement agreement goes from NJSA to a JSA, where the court will approve the non-judicial settlement agreement, which, to Ryan's point, gives everyone involved a level of comfort and finality to it. One of the issues that we've also looked at is if there's a trust in Massachusetts and it qualifies under the Kraft case, is it possible and perhaps desirable to go through a multi-step transition? And as you'll see on slide 25, there could be an initial decanting from the original Massachusetts trust into a second Massachusetts trust, where the sole distinguishing factor in that second trust is that it gives the trustees the ability, the discretion, to change situs and governing law. And indeed, then the trustees, I'll call it Massachusetts Trust Number 2, then indeed changes situs and governing law to another state with more liberal / progressive provisions. And then once assets have been, there's a third trust, and then there's a decanting once the assets are into the new progressive state. There is a possibility, again, where there's concern over uncertainty, that the trustees can provide a 60-day notice to beneficiaries indicating that if they have a concern, they have the right to object, and if they don't, then the trust decanting and change of situs is final. We've, as I mentioned, periodically trustees, because these are new techniques, may seek indemnification from the beneficiaries who are ultimately receiving the benefit of these more favorable trust language changes. Clearly, in these multiple trust transaction, it would be ideal to be able to retitle the assets from Trust 1 to Trust 2, Trust 2 to Trust 3. The question is, that could be administratively burdensome, and is it necessary? IRS cases, in terms of talking about direct and indirect transfers, go both ways. So ideally, the answer is yes, unless it's incredibly burdensome. A quick point, and I would not recognize that we're at 12:59. There were 3 Delaware Supreme Court cases that came out on October 4th, 2013, the Payerl's opinions, and it's very interesting because in that case, if you read the language, there was a governing law provision. There was no change of situs, there was no change of governing law provision, but the court said, absent evidence that the grantor intended the laws governing the administration of the trust at the inception of the trust, that they always govern the administration, a settler's choice of law is not absolute and irrevocable. If the trust allows the appointment of a successor trustee without geographic limitation, and I would say that's almost the case, then the grantor has manifested an implied intent to change the law governing the administration. So there's a wonderful series of cases in Delaware. On slide 27, there's just a reaffirmation of the law in New Hampshire concerning governing law, which in the interest of time we're going to skip over, which will lead us back to Steve on tax issues.
Yeah, this is the final slide, slide 20. Slide 20. Yep, now we got it. Slide 28. Really, it's just a cautionary note regarding generation skipping tax, gift taxes, and income taxes. Certainly, in the 60 seconds we have left, we won't cover too much of generation skipping tax, but really what to look out for here is a grandfathered trust. Remember, pre-mid-1980, trusts are grandfathered trusts for purposes of the GST, also trusts for which GST exemption has been allocated. The issue here is to watch out when you're migrating a trust to make sure that you do not shift beneficial interest to a lower generation. Otherwise, you could blow the GST. From a gift tax perspective, the cautionary note is to just watch for shifting beneficial interest. Again, you don't want an inadvertent gift resulting from a decanting or modification. And then finally, the income tax issues, again, also usually quite manageable. There's a very, very helpful decision called the cottage savings case, which really describes how to avoid income taxation, and usually state income taxation follows the federal rules for this purposes. The issue there is really to make sure that there's no exchange of interests. So that wraps up our direct presentation. Mike, I understand we have a couple of questions.
Yeah, thanks, guys. So we are sensitive to your time. Just to let everyone know, we are recording this session, so if you do have to drop off the call, you will have the opportunity to hear the question and answer. We will share that recording with everyone. So if you do have a question, you can use the question feature on your control panel. I did want to make a quick announcement here that we actually have 2 other sessions coming up that have a trust in the state's focus. On April 21st, we're holding a session on the role and responsibilities of trustees and avoiding litigation. And then on May 19th, we'll present on complex issues in the state and trust administration. Both of those sessions will be held at our Woburn office, so stay on the lookout for additional information on those. We do have a couple of questions that have come in. The first one here, please comment on trustee liability and protection from later claims by wrong beneficiaries that trustee promoted or permitted a benefit change.
That's an area, this is Bill Zorn, that I think everyone is very sensitive to. We briefly alluded to the trustee's duty of impartiality, and when there is a trust modification, whether it's through whatever of those techniques from a change of situs and different laws, the trustee needs to be extremely mindful of that issue. So I would say there is certainly potential liability exposure depending on what those new trust terms say. Having said that, in many techniques, whether it's a non-judicial settlement agreement, whether it's a decanting or whether it's a modification, in all those situations, the trustee does have the ability, clearly in a non-judicial settlement agreement, where you're having all the beneficiaries sign off, and in both Massachusetts and New Hampshire, there's the concept of virtual representation. So beneficiaries that are similarly situated, or in certain situations, parents on behalf of minors and unborn children can sign off on behalf of those beneficiaries. So clearly making sure that beneficiary consents are received is the ideal way to go on that issue.
All right, the next one. Do trustees have potential liability for not changing situs and governing law to avoid state taxes?
So I think a couple of us are going to tackle this. One point that's worth mentioning is that the Massachusetts Uniform Trust Code specifically provides that a trustee may, but has no affirmative duty to change the principal place of administration of a trust. Whether that statute would cover a trustee from liability for failing to move to a tax-friendly state is unclear. We don't have a case or a statute directly on point to that effect. So the question is, would Section 108 of the Mass UTC directing that a trustee does not have an obligation to move the principal place of administration be enough to protect the trustee from liability? Certainly that would be the argument from the trustee's standpoint.
Just to add to that, from a trustee perspective, while it's not clear that there's an absolute duty for the trustee to move to a more tax-friendly jurisdiction, it certainly makes sense within the scope of their fiduciary duty to consider it. But it's also a very important reminder that don't let the tax tail wag the tax dog. In other words, tax is not the only consideration. Bill, in particular, went through a whole list, as did Ryan, of differences among state law with respect to non-tax issues. So while it's important to consider tax issues, it's certainly not the end of the story, and there's so much more to considering meeting a fiduciary duty from a trustee perspective than tax issues.
All right, well, it doesn't look like there are any other questions, so thank you, Bill, Steve, and Ryan, for taking the time today, and thank you to everyone for joining us. Again, stay on the lookout for additional information on our future sessions, as we do hope to see you at one in the near future. Thank you, and have a great rest of the day.